my Lord, the Chief Justice raised certain queries and asked me to take those up. And before I commence the arguments, I would first try and answer the queries that my Lord raised. And the question that, the first question that my Lord raised was the names of the persons mentioned in the examination in chief of Masood Mahmood. The names are, my Lord, Waqar Ahmed, Cabinet Secretary. This is at was Waqar Ahmed, my Lord, Cabinet Secretary, Haq Nawaz Tiwana.
Just also tell us, was he produced as a witness?
My Lord, in the next question.
No, keep telling us, Waqar Ahmed produced?
No, my Lord, Waqar Ahmed was not produced. Haq Nawaz Tiwana, former DG FSF.
Haq Nawaz
Tiwana, my Lord, former DG FSF. He died, my Lord. Then Mr. Said
died at the relevant time he was alive?
Not at the time of the trial, my Lord.
Okay.
Then, my Lord, Said Ahmed, Chief Security Officer of the Prime Minister. He was examined, my Lord.
Chief Security
Officer, my Lord, to the Prime Minister. He was examined.
Examined as?
PW2, my Lord.
Prosecution witness.
My Lord.
And what did he say and did it?
Sorry, PW14, my Lord.
And what did he say and did it conform with what Mr. Masood Mahmood had said?
My Lord, he in actual fact was the main collaborative evidence that the prosecution produced.
Which one?
In fact, Sayyid Ahmed Khan, my Lord. He was the only evidence that was produced to collaborate the statement of the approver, Masood Mahmood.
So is they are the same in material terms or they're different?
My Lord,
Mahmood's and Said Ahmed's statements.
My Lord, they are not essentially same in material terms. The gist may be the same, but by and large, they are different, and the very credentials of Sayyid Ahmed Khan are also questionable. As
Sayyid Ahmed Khan was a government servant?
Yes, my Lord.
Grade?
Grade 21, my Lord, if I'm not mistaken, my Lord. My Lord, if your Lordship would see paper book CMA number 1582.
Are we done with the names?
No, my Lord. Then we have Mia Muhammad Abbas, Director Operations of FSF. He was examined. He was a co-accused and he was examined. Then we have Muhammad.
As what?
As
PWDW.
Accused. He was an accused, my Lord.
342.
Examined as?
At 342 iska hua tha, my Lord.
He has not been examined.
Not examined.
He has not been examined. वो तो मुल्ज़म था जी
मैं मुल्ज़म था
बयान दिया
जी उसने बयान दिया under 342.
So okay, to that extent.
Yes, my Lord, to that.
And what does he say in a nutshell?
My Lord, he in a nutshell talks about how the operation was conducted and how
he implicates or exonerates.
He does not mention Mr. Bhutto as such. He talks about the orders being passed down to him by Masood Mahmood and how the operation or so-called operation then went on.
इस 342 में माना है 342 में माना है
उसने कन्फेशन में माना है
कन्फेशन में माना है
और 342 में उसने
रिट्रैक्ट किया है
ट्रायल में ना वो एग्जामिन हुआ ना उसने कोई ऐसा बयान दिया
जी सर
ट्रायल में नहीं दिया
he retracted in 342
वो तो दे दिया वो
जी
वो इनका 164 रिकॉर्ड हुआ था
वो इसका 164
और फिर वो रिट्रैक्ट कर दिया
जी माय लॉर्ड
रिपोर्ट में उसने कोई ऐसा बयान नहीं दिया
रिट्रैक्टेड इन 342
जी
पहले
And then, my Lord, there's Abdul Hamid Bajwa, who was assistant to the chief security officer, Saeed Ahmed. He also died. He was not examined.
Assistant to Saeed Ahmed.
Saeed Ahmed, my lord.
Not examined.
Not examined.
He died during the trial?
He died probably prior to the trial, my lord. Then, my lord, there was
These people died of natural causes?
natural causes, my lord. I'm hazarding a guess on that. What is believed is that they died of natural causes. Then there is Mr. Welch, who is Director FSF.
What's his full name?
Mervyn Rupert Welch.
How do you spell the first one?
MERVYN.
E-Y-N.
N, my lord.
G. R-U-P-E-R-T.
RUPER.
Rupert, not T.
Rupert. No, my lord.
Welch.
Welch, my
And
lord.
he
WELCH.
And he was?
He was, my lord, Director FSF Quetta.
PW4.
And what is
He was PW4, my lord. He was examined,
PW4?
my lord.
And what does he say?
My lord, he talks about the time when a delegation of the opposition went to Quetta, and Mr. Kasuri was there, and he was told that he is to be looked after within inverted commas, and eventually nothing transpired and nothing happened, my lord. That's the gist of his deposition. And then, my lord, there is Riyasuddin Ahmed. Riyasuddin Ahmed. He was Defense Secretary, my lord. He was not examined. Then there was mentioned is General Fazlim Mughis. He was also Defense Secretary. He was also not examined.
General?
Mughis.
Pura naam kya hai?
General Fazl Mughis.
Mughis.
Mughis, my lord. Mughes.
Not examined.
Not examined, my lord. He was Defense Secretary. And then Mr. Aziz Ahmed was mentioned. He was Minister of State for Defense. He was also not examined, my lord.
इनके घर पे फोन आया था सुबह मुल्तान में आगे पढ़
My lord, the second question that your lordship, that your lord had raised was whether in the examination in chief or in the confessional statement of Masood Mahmood, there was any direct direction, orders of Shaheed Zulfiqar Ali Bhutto with reference to explicitly stating that Ahmed Raza Kasuri be killed, or words to this effect. My lord, from the perusal of these two statements by myself, I have not been able to come up with any direct orders or direct words which have been said by Masood Mahmood. There's one single exception, my lord, and that is also after the incident, and that is your lordship would find Masood Mahmood's statement or examination in chief at in volume 2, my lord, page 64, and the relevant portion is at page 75. Type page 75.
Can you just read it?
Yes, my lord. It says, this is subsequent to the incident having taken place in Lahore. He says,
After the killing.
after the killing, my lord. Although at the meeting that I had with Mr. Bhutto after the murder, he piped down after hearing me. There were other occasions, now this is the relevant portion, my lord. There were other occasions on which he continued to goad me into getting Mr. Ahmed Raza Kasuri assassinated. So this is his own words which he is using, and there is otherwise nothing which is connected directly to Mr. Shahid Zulfiqar Ali Bhutto, my lord. So since this was there, and since
Is it not surprising when we are talking about a court of law and not someone's drawing room?
my lord,
If in a court of law someone testifies, take care of him, would not the judge ask what do you mean by that?
my lord, it should be, and
If not the prosecution or the defense.
my lord,
Maybe the defense would not want to cement the case against the accused, but certainly the prosecution should clarify. So what do you mean by taking care of someone? I mean, you may be going to court and say, take care of whatever. I mean, it may be misconstrued also.
yes, my lord, the word take care of has more than one meaning, and
The obvious meaning is to look after someone
Yes, my
in a
lord.
positive way.
yes, my lord.
But it's also used in a negative way. But then should that not be asked to the
My
witness?
lord, I am trying to get my hands on a judgment, which when I do, I will supply to your lordships, and that is of England, sometimes in the 50s, when there were two hooligans who were breaking into a biscuit warehouse, and one of them was a juvenile. He was in front and the other one was behind him, and the one behind him, when they were encircled by the constables, said to him, let him have it. And the boy took out a pistol and shot one of the constables. The elder hooligan was subsequently convicted for murder, and he was sentenced. But subsequently, the matter went before the Lords in appeal, and they then came to the conclusion that the word let him have it has more than one meaning, and therefore he was then granted a royal pardon. This is the Bentley case, my lord. I'm trying to get my hands on it. The moment I do, I will supply it to the
You can cite a case from our own jurisdiction, the Indo-Pak jurisdiction, which was previously they used to order he be hanged,
my lord.
and then someone raised the objection. It doesn't say kill. So then they started adding the word till he is dead.
Dead.
Previously, they would not say these words, and that benefit was given for till he is dead. Okay, hang him, not take him down. So this is I don't have the reference, but
My lord, now I would come to this. If your lordships would be good enough, I have supplied another
brief synopsis,
my lord. This is only 10 pages, and I will just very quickly read your lordships through it, because otherwise it would consume a lot of your time if I was to go into details. My lord, the first question is that of admissibility in Article 186 of the Constitution. The instant reference, the words any question of law, appearing in Article 186, Constitution 73, are of importance, as there is a point of view that in advisory jurisdictions, matters decided in adjudicatory jurisdiction cannot be considered. The word law envisages civil law, criminal law, conventional law, customary law, divine law, elementary law, enacted law, federal law, fundamental law, and international law. That according to Black's Law Dictionary, 10th edition, at page 10015, the word law includes judicial precedent. And this I've attached, my lord, with paper book 1 at
we can
tab
see that.
3, my lord. Then we go on further, my lord. That common law, according to Black's Law Dictionary, 10th edition, at page 334, is the body of law derived from judicial precedent rather than from the statutes and constitutions. In Pakistan, there is a mix of common law, Sharia, tribal, and civil law. It is a mixed system of law, and this again I have annexed. Further, in Black's Dictionary, 10th edition at page...
We got the point.
My lord.
Go to the next point, we'll read it.
Right, my lord. My lord, then the word law includes what I'm trying to show to your lordship says that the word law includes precedent law. And then I have quoted from Justice Mansoor Ali Shah's judgment in PLD 2024, Supreme Court 7 at 22 at Supreme Court 7 at page 12, paragraph 5.
But
And
won't this, on the contrary, weaken your contention?
no, my lord. If
Well,
I,
it says finality of decision of the Supreme Court.
Yes, my lord. What I'm trying to emphasize here is that precedent law is something which is to be followed by all courts under Article 189. And therefore, it is essential for this court to look into the question of whether the judgment of
मैंने किया लेकिन मैंने इतना पोर्शन किया फ्रंट भी वाला बाकी
And then I go on to say that, my lord, that in Article 186, the president is asking for an opinion from the Supreme Court and not a judgment. An opinion is an estimation and not like a judgment or final determination. It is like a legal opinion given by counsel to his client, and this has been fortified in the Attorney General for Ontario versus the Attorney General for Canada, 1912. Therefore, the opinion sought in the instant reference is whether the case reported at PLD 1979, Supreme Court 53, can be termed as precedent law under Article 189, Constitution 1973.
Would you like to replace the word can with should?
Should, my lord, I would. I'm grateful. My lord, then I go on to say that the premise that the adjudicatory jurisdiction of the Supreme Court cannot be subject matter of an opinion under Article 186, Constitution 1973, in the instant reference is flawed. And I say this for the reason, my lord, that the Lahore High Court and the Supreme Court were not functioning as courts under the Constitution.
Why?
My lord, I have given, I have cut that down by my lord, but in the mainstay of my arguments, I have stated that the proclamation of emergency.
Because of that?
Yes, my lord, martial law. The proclamation of emergency of 5th of July, 1977, in its Article 2, clearly states that the Constitution is in abeyance. Then the Law's Continuance in Force Order 1977, which also came on the 5th of January 1977, places fetters on the functioning of the superior courts, that is the High Courts and the Supreme Court. The Law's Continuance in Force Order 1977 also takes away all fundamental rights that were guaranteed under the Constitution 1973. That would mean that Article 4 was not available, nor any of the fundamental.
As observed by some members of the bench, then there were acquitting judges also.
My lord, acquitting judges were there, but at the same time, the courts, according to the law that was prevalent at that time, was the courts were functioning under various instruments of martial law. They were not functioning under the Constitution.
They were not independent, that's what.
And they were not independent, and therefore the provisions of a fair trial were not available, as the fundamental rights had been taken away. The jurisdiction of the courts themselves had been placed placed under fetters by the law's continuance in force.
That would apply to all the cases during that.
That would apply, my lord, very essentially to all the cases, but essentially this case is before your lordships at this point in time, and your lordships is also looking at
If we apply the cases to all points, or we can distinguish that the prosecutor had a particular interest, or whatever you want to call it, the person in government. I mean, normal murder cases may, between two individuals, he may not have a particular interest to achieve a particular result, because otherwise you open it too wide. I think you have to narrow it down if you're going to.
My lord, as your lord has pointed out, that the prosecutor, that is General ZA, had a particular interest, and this interest is evident from the 5th of July, 1977.
Then we can narrow it down.
And my lord, even if one was to look at it prior to the 5th of July, you would find that an agreement had been reached between, that would be dwelling into the political domain, but just for your lordship's consumption, that prior to the 5th of July, on the 3rd of July, 1977, a agreement had been reached between the government of Shahid Zulfiqar Ali Bhutto and the opposition that fresh elections would be held. And
was that signed or not?
my lord, the only thing that was left was its signing. And then on the night of the 4th and 5th of July 77, General Zia moved and imposed martial law. And one of the first...
The point which I think, which has probably not been mentioned or not stressed enough, was if it was a continuation of a trial, this had gone dormant.
Yes, my lord.
Untraced, 74 incident, Justice Shafiur Rahman's report comes in, and then it re-emerges. You know, that there must be something there. And then another aspect is that the complainant joins forces with People's Party or Mr. Bhutto seeking a ticket. I mean, what do you want to say about that?
My lord,
Has he forgiven or he had erred?
my lord, coming to the first part of your...
He's scared. I mean,
My
it could be
lord.
one of three things.
My lord, coming to the first part of your observation.
Number 4, I will add to on number 4 that he realized that Mr. Bhutto was not involved in it.
Erred. Yeah.
My lord, coming to the first part of your observation, my lord, the intent becomes evident from the fact that on the 5th, an inquiry is ordered into the performance of the FSF. This is one of the first steps that General Zia takes. Then on the 24th, if I recall correctly, my lord, on the 24th of July, 3 FSF directors are arrested. Inspectors, sorry. 3 FSF inspectors are arrested. And on the 25th, they are arrested on the 24th of July. On the 25th and 26th of July, 77, their confessional statements are recorded before a magistrate.
Which
on
date?
On the 25th and 26th, my lord, of July. Again, on the 5th of July, Masood Mahmood is taken into custody. Masood Mahmood, when taken into custody on the 5th of July, is first shifted to a mess in Rawalpindi. From there, that very evening, he is shifted to Abbottabad. where he is kept in confinement. Then on the 14th of August, 1977, he writes a
Where are you getting all these facts from?
my lord,
Are they part of the record?
They are part of the record. They are part of the judgment, my lord.
Okay, they are part of the judgment.
They're part of the judgment.
इसकी कोई फैक्ट शीट बना दीजिए ना आप इसकी फैक्ट शीट है इसकी कोई बनाई है इवेंट वाइज
So बनी हुई है, बनी हुई है.
Paragraph 9 of the judgment, main judgment में है.
So then, are you saying that they were not voluntary statements, they were coerced? Is that the point? you're making?
Yes, I'm trying to make that point that they were given under custody of martial law.
Or duress or what?
Or duress, and that he then writes to ZA on the 14th of August. After about 3 or 4 days, he's contacted by the FIA. Then he's brought back to brought back to Islamabad, where he makes his confessional, where he makes a statement under 164. Then he writes to the magistrate asking for a pardon, and then he makes his confessional statement at Lahore. So therefore, your lordship would see that there is a steady prodding along by the marshal.
What are the names of the actual people who are stated to have pulled the trigger?
My lord, the ones who have pulled the trigger are Iftikhar, my lord, Inspector Iftikhar.
Iftikhar what? Iftikhar.
I'll just give you the name.
Was he an approver or a,
No.
he was co-accused?
Yes.
All.
I'll just give your lordships the three names,
Okay.
my lord. And I'll just give your lordships the three names. And then your lordships will see that there is, with due respect, there is not only this manipulation which is taking place with reference to the witnesses, but there is another manipulation which has taken place, or which took place.
In all these years since 74 till 77,
my lord,
has it come on record that I wrote this to my wife, to my whatever,
my lord, all of
my
this,
boss, saying that I've done this, of the approvers of the confessional statements?
My lord,
the incident took place in 77.
Yes,
we're now 74, and now we're talking about 77.
my lord.
So I mean, my conscience may be troubled, and I may be telling somebody.
My lord,
or there was total blank silence.
My lord, I would be misleading the court if I was to make
There's nothing on record.
There's nothing that I have been able to find which is on record, my lord. My lord,
because the troubled conscience should not be troubled only when the regime changes. It may be troubled. You may write
prior also.
Your friend, you may write.
My lord. My lord, the names are Rana Iftikhar.
ये क्या थे? Inspector थे?
Inspector थे, my lord.
Rana Iftikhar.
Arshad.
Arshad what? Arshad. जी.
And Ghulam Mustafa.
ये भी Inspector FSF के सारे थे.
ये तीनों FSF के थे, my lord.
गुलाम मुस्तफा के बारे में बताया गया था कि उसने तो खाली असला मुहैया किया था.
नहीं सर, वो अप्रूवर है.
नहीं
ये उस ऑपरेशन में शामिल था. गुलाम मुस्तफा, सूफी गुलाम मुस्तफा इसका पूरा नाम था.
He was in charge. He was looking after. He was supervising the squad who actually pulled the trigger. It was those two gentlemen who pulled the trigger. He was supervising.
My lord, the other manipulation that
one more thing,
my lord.
Did it come in record that they had also committed other murders?
No, my lord.
Similar?
No.
On the behest of Mr. Bhutto?
No,
allegedly?
No.
Huh?
There was no other allegation against Mr. Bhutto of any other.
No. When they're confessing,
no, my lord.
Comes and confesses,
no, they have not named Mr. Bhutto at all.
No. I think my question is slightly different.
My lord.
The person comes and confesses or says something. But these people did not confess.
No, they made 164 statements on the 25th and on the 26th.
Iftikhar and Arshad and Sufi Ghulam Mustafa.
On the 26th of July, my lord, they made statements,
confessing
164 statements.
In that confessional statement, did they say I had also committed the murder of so and so and so and so and so and so?
No, my lord.
Okay. No. So this is the only murder they confessed to.
My lord.
नहीं, एक तो होता है ना, you have a hitman for, let's go along with the prosecution. So that hitman would not just do one job, he probably will do other jobs.
As well. But there was no, that was not brought on record, my lord. My lord,
ऐसा तो जिक्र आया था ना कि उन्होंने असला जो पहले मुहैया किया था वो किसी एक्टर मोहम्मद अली और एक और किसी बंदे का जिक्र आया था कि उनको मारने के लिए भी
So वो if I remember correctly वो शायद गुलाम मुस्तफा ने
कहा था
जी सर
कि हमें असला वो मुहैया किया गया
था। फिर उन पे फायरिंग की उन्होंने मोहम्मद अली पे या नहीं की?
वो उस पर
फायरिंग की थी।
मुहैया हुआ था सर, उसके बाद साइलेंट ऑन. The other manipulation, with due respect, is that the Chief Justice or the acting Chief Justice of the appointment of the acting Chief Justice of the Lahore High Court. On the 5th of July 1977, when martial law was imposed, and I have added that to the paper book, which is with your lordships, which has PLD written on it. The order is there where by way of a martial law order, the chief justices were made governors of the province, and Mushtaq Hussain, Justice Mushtaq Hussain, was made the acting chief justice of the of the Lahore High Court. Now, this appointment was also not under the Constitution. So this would tie in with my earlier submission, which I had made, that the courts were working under martial law instruments.
Why don't you take the other better point? That the executive is now joining hands with the judiciary. Because
on page 51,
governor is an executive function.
My lord, on page 51 of the main paper book, CMA, I have said that there is a triangle of the Chief Martial Law Administrator, the Chief Justice of Pakistan, CJP, and the Acting Chief Justice of Lahore, as an acquittal would have adverse consequences for them in terms of losing their respective positions and in furtherance of an international and internal conspiracy for the region and the country.
आपने अंग्रेजी ज्यादा खूबसूरत इस्तेमाल की है।
My lord, the appointment of the acting Chief Justice, my lord, it would be borne in mind that there were the leaders of the Pakistan People's Party.
How long did they remain as acting governors? The duration, was it a few days or something?
No, my lord. They continued because during the course of the trial,
roughly?
It would be about almost a year and a half, my lord, because during the course of the trial, it is said that Justice Mushtaq Hussain said that he should be made the permanent Chief Justice of the Lahore High Court. An amendment was made.
No, I'm talking about acting governor.
My lord, I'm coming to that. An amendment was made whereby Justice Riaz Hussain had to be elevated to the Supreme Court so that a vacancy would occur in the Lahore High Court. So an amendment was made in the order of the appointment of the acting governor through a martial law instrument, whereby he was allowed to continue despite his elevation to the Supreme Court. He was allowed to continue as acting Chief Justice, as acting governor of the province of Punjab. And your lordship would see that the judgment.
You're talking about Justice Mushtaq Hussain?
No, my lord, I'm talking about Justice Riaz Hussain, who was the acting governor of Aslam Riaz Hussain, who was the acting governor of the province of Punjab. And since that amendment was made, therefore a vacancy was created in the Lahore High Court.
You've lost me.
I'm sorry, my lord.
Chief Justice Lahore High Court.
My lord, the Chief Justice of the Lahore High Court was under a martial law order. Justice Riaz Hussain, my lord. Aslam Riaz Hussain was under a martial law order made acting governor of the province of Punjab.
ठीक. All
Just-
chief justices.
All just Chief Justice, my lord. Justice Mushtaq Hussain was made acting Chief Justice of the Lahore High Court. Right, my lord?
Got it.
Now, it is said that Justice Mushtaq Hussain, during the course of the trial, when the matter was before the Lahore High Court, put up a demand to the Chief Martial Law Administrator that I should be confirmed as the Chief Justice. This is borne out by the fact that Justice Riaz Hussain was elevated to the Supreme Court. An amending martial law order was passed, whereby, despite the fact that he had become a member of the Supreme Court, was on the bench of the Supreme Court, he would continue to be the acting governor of Punjab.
But this animus would be then with Aslam Riaz Hussain or not with...
No, my lord, my lord, I'm just coming to that.
Ji.
This was done, and Justice Mushtaq Hussain was made the permanent Chief Justice of the Lahore High Court.
Okay.
And the judgment and the judgment, the trial court judgment that has been signed.
So are you saying that Justice Aslam Riaz Hussain simultaneously held the position of a Supreme Court judge as well as...
Yes, my
governor of the
lord.
province?
Yes, my lord. Yes, my lord. This was done through an amendment, by an amendment. If your lordships would like, I can show that amendment to you.
No, but then why did they not just make Justice Mushtaq Hussain both positions? He could have held them. He could have been that.
My lord, he couldn't have been the acting Chief Justice and the
He
acting...
could have been the Chief Justice and the acting governor. Why not?
No, my lord, because the previous martial law order provided that the Chief Justice of the High Court will become the acting governor of the province. So therefore, if he
मैं
had...
समझ गया आपकी बात.
जी सर.
अगर यही बात थी तो असलम रियाज हुसैन साहब को तो ऊपर ले आए ना सुप्रीम
सर
कोर्ट.
ऊपर ले आए
तो फिर अब मुश्ताक साहब को वो चीफ जस्टिस भी बना दें और एक्टिंग गवर्नर भी बना दें.
सर फिर he would have had to leave the
Trial नहीं कर
खैर ये मैं
सकते थे
समझ
वो।
नहीं पा रहा हूँ. Anyways, इसकी जरूरत क्या है?
ट्रायल नहीं कर सकते थे ना फिर
ट्रायल नहीं
acting
चला
governor
सकते थे
बनते
सर
तो।
क्योंकि वो गवर्नर बन जाते तो then he couldn't have sat as the Chief Justice.
अच्छा, okay, that's the point. right?
That's the point. I'm
My-
sorry, I was a
my-
little
my
foggy
colleague has
in
hit
my
the nail on the head.
arguments. I apologize. But
Very-
that was the point that I was trying to
Okay,
make.
okay.
वैसे माशाल्लाह ऑर्डिनेंस के तहत कुछ भी हो सकता था. गवर्नमेंट ट्रायल भी चला सकते थे अगर वो चाहते.
तो वो तो बादशाह थे जो मर्जी मार्शल लॉ में करते. The other point that I was making, my lord, was that Begum Nusrat Bhutto challenged the challenged the detention of certain leaders of the Pakistan People's Party before the Supreme Court. Justice Yaqub, who was then the Chief Justice, and I can just give your lordships the dates, on the 21st.
So if you can just tell us the point you're making.
Yeah,
It
my
may
lord,
not be necessary.
the point that I'm making is that Justice Yaqub was removed from the office of the Chief Justice after he admitted the petition for hearing.
Yeah, He's now Justice Yaqub
Is the Chief Justice of Pakistan.
is.
He was removed from office by, and here again, a special martial law regulation was brought, and he was removed from office, and Justice Anwarul Haq was made the Chief Justice of Pakistan.
What happened to Justice Yaqub? Sent home?
Sent home, my lord.
ठीक.
So this is the troika that
Are you done?
No, my lord.
We will certainly read what you've written.
My lord, just give me another 10 minutes, my
ठीक.
lord. My lord,
बाकी साहब एक क्वेश्चन है प्लीज. इसमें जो ट्रांसफर हुआ था हाई कोर्ट फ्रॉम सेशंस टू हाई कोर्ट,
जी.
उस ऑर्डर में is there any specific reason for transfer in terms of
No, my lord, there is
526?
no, my lord.
आप ही के लिए पूछ रहा हूँ. कोई specific reason है within the domain of section 526 of CRPC?
No, my lord.
As to why, what is the necessity to transfer the case from sessions to the High Court?
My lord, not. My lord, Malik. Criminal miscellaneous applications were filed before the Lahore High Court, and they were
They
disposed
have
of.
not dealt with any specific reasons.
Application were taken into consideration, and it was written that for the reasons mentioned in the application, the case is hereby transferred from.
Gee, but they were.
So reasons were there.
no reason.
He did not wrote down himself, but he say the reason mentioned in the application are taken into consideration.
Yes, my lord. It was not a speaking order as such,
Yes,
my lord.
it's not.
Yes,
It was not a
that
speaking.
is why I'm
Ji,
trying
ma'am.
to ask this question.
Ji, ma'am. It was not a speaking order. My lord, very, very quickly, I'm grateful, but very quickly, my lord, in the advisory jurisdiction, my lord, and I'm now trying to address something that my lord.
इसमें advisory के लिए भी आपने paragraph 3 and 4 में लिखा है कि no factual inquiry is required, nor
sir.
any inquiries to be made.
Ji, sir.
So only these are some admitted facts on which the opinion can be rendered by
Jesus,
this.
Jesus, because I have stated that there are two that the president can seek opinion on two types of questions of law. One is a question purely of law. For example,
One is the wider meaning of law.
yes, my lord, and one is the wider meaning of law.
Got
The
it?
question is that this judgment of the High Court and Supreme Court should not be treated as precedent under Article
That-
199
that's
of
correct, my lord.
the Constitution.
Yes, my lord, and then I've gone on to like your
While
lordship,
you're on the question of advisory jurisdiction,
my lord,
a hypothetical question I'm asking you.
my lord.
You know, in judgments, we give short orders. Can we give short opinions in advisory jurisdiction?
That's up to the court, my lord.
Can we?
Yes.
Okay.
Then, my lord, I'll very quickly skip on. Then I've said that the court in the advisory jurisdiction can go on to Article 187. This has also been argued, and I have also dealt on that. And I've said that here no factual inquiry is as such
But
required.
I would not agree with you. That's a jurisdiction which is invoked in alive cases, or for want of a better phraseology, when you're dealing with a particular writ or a appeal or whatever it is, you can invoke 187. But can you tie up 187 with 186?
Yes, my lord. According to me, you can, because for the simple
I
reason.
think
You need to have a jurisdiction. The
करेंगे?
court must have jurisdiction
if
first.
we take,
187.
Rabbani Sahib, if we take any cognizance under Article 187, then the opinion will be converted into judgment. Because
No, my lord.
yes,
My lord, your
under
lordship,
Article 186,
your lordship would
we
be.
have to give the opinion. And if we pass any order under Article 187, that would be a judgment of the court.
175, it's all the language, not of
Any case
186.
pending.
देखिए लिखा है ना, the Supreme Court shall have power to issue such direction, orders, or decrees as may be necessary for doing complete in any case or matter
Pending.
pending before us.
Exactly.
Now, this is not a matter or case pending before us.
It's
I
a
don't
matter
see
which
how
is,
we can
it's a
use 187.
it's a matter pending before you.
No, but it's not a-
Reference is a matter pending before you.
Case. No, no.
distinction.
There's a case or matter would be not of the genre of 186. That's an
Doing
opinion.
complete justice in any case or matter pending before it.
Now, suppose, let's say this matter lay unattended for 10 years.
Yes, my lord.
and we leave it unattended for the next 100 years.
My lord.
It's not a matter pending. A matter pending is something which requires adjudication. I would assume. Yes, we should attend to it, but the word case and matter should be read
With the word
together.
pending, you're saying.
Yes, I don't think we can stretch it here, unless you can persuade us. I'm not of that view.
My lord, in order to do complete justice, Justice Dura Patel also in his dissenting note had said that the primary object is to do complete justice, and complete justice would only be done.
I'm troubled there also.
complete justice
He could have excised the review pass. He became unanimous there. So I don't know. I mean, that option was open to him in review. He could have certainly reiterated, said, "How can I sign something?" Which
So your basic contention is that as far as case is concerned, yes, this is not a case. But as far as matter is concerned, 186 is a matter,
My lord.
which comes within the advisory reference comes
right.
within the purview of the word matter.
Yes, my lord.
Hence, we can exercise in one.
A window could be opened, my lord.
अगर आप 2 पढ़ेंगे तो वो आप जरा negate ना कर दें.
लैंग्वेज बिल्कुल डिफरेंट है रबानी साहब
Any such
186
direction.
187 में
We're not issuing a direction in an opinion.
डायरेक्शंस डिक्री तो वो तो फिर बिल्कुल चेंज ही हो गया ना उसका जो
हम उसको जजमेंट बना रहे
वो
हैं.
तो जजमेंट बन जाएगा वो इट विल क्रॉस द बैरियर ऑफ ओपिनियन इनटू ए जजमेंट ऑफ द कोर्ट
तो आप ये भी कह सकते हैं कि हस्बा बिल के बाद जो ओपिनियन है दैट हैज बिकम एन ऑर्डर नाउ.
Yes, my lord, but I tend to agree with what your lordship has observed.
I'm not मैं आपके लिए बता रहा हूँ कि आप
जी, sir.
ये भी कह सकते हैं कि
It's become binding, man.
now there is no difference between
of article
case and
186 not 187
असबाब बिल वाला ऑर्डर कितने जजेस का था?
Nine.
And we are 9 as well.
Gee, you're 9 as well.
we can do that.
Can one disagree with Hasba?
Yes.
Go on.
Then finally, I will just come to the effect on martial law. Finally, I'll just take 2 minutes on the effect of martial law.
नहीं आपने जो मेन आपका वो था कि बायस का अब वो इश्यूज जो बायस के उठाए गए थे और जिन पे फाइंडिंग आ गई है उनके अलावा कौन से ऐसे इश्यूज थे जिस पे आप कहते हैं कि ये बायस था? देखिए आपका मेन कंटेंशन जो मैंने आपके उसमें फाइल में पढ़ा वो बेसिक आप एक मार्शल लॉ की तरफ गए थे, दूसरा आप बायस की तरफ गए थे. बायस जो ग्राउंड्स which were taken during the High Court and before the Supreme Court on bias which had been decided, वो आप अलग कर दें. आप बोलें कि इसके अलावा कौन-कौन से फैक्ट्स हैं जो कि बाद में अराइज हुए हैं, which were not before the High Court or before the Supreme Court, ये फैक्ट्स आए, उनके ऊपर हमें आप ओपिनियन दें. वो कौन से फैक्ट्स थे जो शो करते हैं कि बायस था?
वो my lord, then
अगर आप हमें आप हमें जॉट डाउन करके दे देना
ठीक है, सर.
कि ये वो इश्यूज हैं जिस पे हाई कोर्ट ने और सुप्रीम कोर्ट ने फाइंडिंग दी, ये वो फैक्ट्स हैं, ये वो इश्यूज हैं जो कि इस एक्सिक्यूशन के बाद आए जिस पे हम order कर सकते हैं.
Speak, my lord. I'll make that yes. Very briefly, my lord, that the effect of martial law on the basis of dispensation of justice and fair trial. As a consequence of the proclamation of martial law and law's continuance in force order 1977, A, the Constitution was in abeyance. B, Article 4 and fundamental rights in the Constitution were not available. C, the jurisdictions of the courts had been badly curtailed. D, there was no due process of law. As a consequence of President's order post-proclamation 1 of 1977, High Court Judges Oath of Office Order 1977, and this was not the PCO, my lord. This was an oath under martial law regulations. Judges took oath, san the word Constitution. The word Constitution had been removed from the oath. As a consequence of these two, according to me, the courts were not the High Court or the Supreme Court, which were functioning under the Constitution 73. Judges were not judges under the Constitution 1973, and they were functioning under various martial law.
We got the point. We got the point.
Yes, and finally, my lord, that by rule of that there was a rule by law. And this, coupled with manipulation of the state apparatus by the dictator, resulted in judicial system functioning under the instruments of martial law, denying the due process of law. And finally, my lord, the bias of General Zia, I've just pointed out to your lordships on the question of the appointments. The date in Begum Nusrat Bhutto's case was 21/9/1977.
What is it, this date?
My lord, this is the date when Begum Nusrat Bhutto challenged the detention.
Significant?
The significance is that on the 22nd, a martial law order was issued whereby Justice Yaqub was removed from the office of the Chief Justice of Pakistan.
He admitted on case.
This is the date he admitted that.
Sir?
And finally, my lord,
We are concluding today.
Yes, my lord, I'm just concluding. But just one last word that I would say, and then I will take your leave. So, my lord, at the very end, we have that the FIRs pertaining to various attacks on Ahmed. On page 8, my lord, I've spoken about the motive, and that is that various FIRs pertaining to various attacks on Ahmed Raza Kasuri from 1972 till 1974 were registered. There were about 5 or 6, my lord. That in none of the FIRs, Shaheed Zulfiqar Ali Bhutto
This is
was
written
named.
here.
This is written here, my
The
lord.
page, what?
And this is page 8, my lord. And then the at the bottom of the page, my lord, paragraph number 2.
कौन से page में?
Page 8, my lord, ये जो paper book है, ये
The
जो
thicker one or the thinner one?
the thinner one, my lord.
जी.
And at the bottom, my lord, I had reached the bottom of that page, paragraph 2, that the remarks of Shaheed Zulfiqar Ali Bhutto made on the floor of the National Assembly, I won't read them because we are well aware of those, and the speeches of Ahmed Raza Kasuri in the National Assembly, they were taken in as evidence. And my saying is that there was martial law, the Constitution was in abeyance, therefore Article 66 of the Constitution, which is the privilege of a member of Parliament as to his right to what is said in Parliament, and the vote cast by him would not be made will not be called in question in any proceedings.
Yep.
That was not available, and all the collaborative motive, that all the collaborative statements with reference to the motive are given in paragraphs 486, 469, 468, 469, 470, 473 of PLD 1979 Supreme Court 53. My lord.
Did the Supreme Court mention Article 66?
No, my lord, there's no mention of it at all. Because it was not in the field at that time, my lord.
What?
Article 66.
It was in the field.
No, my lord. The Constitution was in abeyance.
No, but otherwise it was in the field.
It was in the field. Otherwise, it was in the field. But
So
the
how can you rely upon something said in the National Assembly?
Yes, that is exactly what my case is. I'm grateful, my lord,
Thank you very much.
for your patient hearing, and I've tried to be as brief as possible.
Attorney General, आपसे हमने एक सवाल पूछा था about Masood